Let me first thank everyone for coming and welcome you to this event, and thanks to Open Dialogue for helping us organize this, and on behalf of myself and Sophie Intervelt and Renew Your Group. Now, we're here to discuss and hear the experience and perspectives of Polish judges and prosecutors who are at the forefront of the struggle for the rule of law in Poland, but also by extension in the European Union as a whole. And a lot has happened in Poland since 2015 in this area. Not all of it good. Obviously today much of the focus also in the media is on the Supreme Court, but the attack on the independence of the Polish judiciary began already in December 2015 with the controversial and unconstitutional reshuffling of the Constitutional Court. So the seeds of the legal chaos that we see today were already sought back then. And then, of course, came the problem with the Supreme Court and the National Council of the Judiciary, which was filled by members sympathetic to the ruling party. There was also an attempt to try to get rid of judges by lowering retirement age. And although this particular attempt was at least partially stopped thanks to the pressure of the European Commission and the European Court of Justice, but the fight for the Supreme Court and for rule of law in Poland continues. And today, at this particular point in time, or rather the Polish justice system, finds itself in a quite a dangerous limbo. Because just last week, as many of you know, the Supreme Court ruled that the disciplinary chamber set up quite clearly to act in the interests of the government was not independent, according to the criteria laid down earlier by the European Court of Justice in its November ruling. Now, unfortunately, this very short description or account of events in Poland since 2015 barely scratches the surface of what has been a widespread campaign to undermine the independence of Polish justice system institutions, to weaken media, or to intimidate critics such as Wojciech Sadurski. And it is, of course, a very sad story from a country with such a rich history and a distinctive ethos in fighting for democracy, freedom, and resisting authoritarian practices. It has to be said that the European Union played quite a visible role when it comes to the rule of law in Poland. The Commission has been for 4 years now engaged in a rule of law dialogue with Poland. It brought numerous infringement proceedings and triggered Article 7 of the Lisbon Treaty. The European Court of Justice, for its part, that actually broke new ground and developed a line of case law that was imaginable just 5 years ago. So while the EU has arguably been more active and done more in Poland than in Hungary or elsewhere where there are rule of law problems, the situation has not really improved. And of course, ultimately, it will be up to Poland and its citizens to protect the rule of law, but we in Renew Europe or the European Parliament believe that the EU should and must continue to support them further. And more generally, I would say this as also the rapporteur of the EU-wide new mechanism on rule of law, democracy and fundamental rights, but more generally the case of Poland also illustrates why the EU needs such a robust and effective mechanisms for objective monitoring of rule of law and European values in all its member states. And finally, I think the case of Poland and the story that our guests will tell us today sort of drives home the point that backsliding on European values in one member state is not a purely national matter anymore. That the EU is a community of law and a community of shared values, and that violations in one country affect all of us. Which is also why our distinguished speakers are not just here because they defend the rule of law in Poland, but because they are the defenders of European values for all of us. And with that, I'll pass the microphone to Sophie, and then we can move on.
So very welcome, everybody. Following on from where Michał ended, the rule of law and more generally European values as laid down in European treaties are not a purely national matter. This is what many governments who are violating the values keep saying that it's a matter of subsidiarity, that it only concerns national authorities and Brussels should not interfere. That is blatant nonsense. And not only because those values are laid down in the treaties and in laws and in the Charter of Fundamental Rights, and that the fact that the member states have voluntarily and knowingly signed up to it. I would just like to point out that this is all laid down in Article 2 of the treaties. It's not somewhere in a footnote which they have overlooked. They knew very well what they were signing up to. And all the laws that have been passed with the majority of the member states and this House. But it's also a European matter because if there is a problem in one member state, it affects the European Union as a whole. The European Union is one legal system. National judges dispense EU law. They are interpreting EU law, so therefore they are also European judges. So if one part of this ecosystem doesn't work, more places, if one part of the ecosystem doesn't work, then the whole ecosystem doesn't work. So therefore, if there is a problem in Poland, or in Hungary, or in Malta, then it has to be addressed by the European Union. And I think the situation in Poland and Hungary in particular also demonstrates that those issues have to be addressed much more quickly and much more thoroughly than is so far the case. Because if it lingers for too long, as is the case in Hungary, then it becomes almost irreversible. And it may take years or even decades before the damage is repaired. So I therefore hope, today we're talking about Poland, but there's also the summit meeting going on at the same time, and I hope that the member states have understood by now and they will no longer linger and discuss the situation in Malta, because that is also very worrying. I have this week written an op-ed in Politicos calling this a rule of law emergency in the European Union, and like with the climate change emergency, the European Union is responding far too slowly, too timidly, turning a blind eye, looking away. So I think I'm proud to be part of this House, which has consistently climbed the barricades for the rule of law, for fundamental rights and for democracy. And we also want to give a podium to those voices who in their own countries are being silenced by the authorities because they take positions that are not favored by the government parties. So that's what I have to say for today. I'm now going to pass the floor to the Open Dialogue Foundation. Ludmila, good to see you again.
Yes, thank you. Thank you so much. Thank you everyone to joining us today, especially considering that we have EU summit and UK election taking place at the same time. And I'm very happy to see that so many of you came and take care about the most pressing issues in Poland, and indeed actually in the very heart of Europe, the assault of the independent judiciary. Before we pass the floor to our honorable guests, I would like to tell you why the Open Dialogue Foundation, organization which is known mostly for human rights defending in post-Soviet region, we became involved in the topic. First of all, we launched as ODF in 2009 in Poland, and now we have offices in Warsaw, Brussels, and Kiev. Until 2017, Poland was a role model for our organization to share the values of democracy, how actual transformation has to be done. But unfortunately, since 2017, when we as personal family, I mean, we say my husband and me, we participated in peaceful protests in defense of rule of law, and then we actually observed what's happening, we became a target for prosecution and attacks in Poland, and we can't unfortunately share our values and say that Poland is a role model for other countries. And after coming to the power, law and justice in Poland, we were pulled in the crisis of the rule of law in our country. And of course, we can't speak about situation with human rights in other countries if we don't actually care about human rights and rule of law situation in Poland. So I'm here actually, and we able to operate thanks to pressure and actually thanks to defense of, first of all, members of European Parliament, and I'm very grateful, Sophie and Alde, that you actually supported at that time us. And I think that this support is now vital for especially these honorable individuals who came here to testify, to share their, huge pain they now suffer. So, and of course, it's about independence of the courts. If we lose courts in Poland, unfortunately, it's a very dangerous precedent for the whole Europe. So for this direct reason, I think this kind of gatherings with direct testimonies is the most important. So I'm happy that there are different members of the political groups who can actually support and listen these individual stories. So now, judges, mothers, ZUREK, prosecutors, Parchimowicz and WRZOSEK, we appreciate you joining us and tell us your stories.
Thank you very much. It says here I'm moderating, so I'll do that then. So I'll first give the floor for 5 minutes to my colleague Rosa Thun of the EPP group. Rosa.
Thank you very much. And thank you really to everybody who came, and so many of you are standing, so that also motivates us to be brief. The fact that this meeting is this hearing of the Polish judges and prosecutors is organized by Sophie Infeld, who is an experienced member of the European Parliament and tirelessly throughout the 10 years I have been observing your work, struggles for human rights everywhere, and now we are also on the list of those countries where you have to struggle for justice, human rights, free courts, free press. This is dramatically sad, but I think it encourages not only citizens of Poland, judges, prosecutors, publishers, writers, etc., to struggle for freedom, but in other countries, because we had issues already with Malta, Romania, Hungary, and now we have to raise the issue of Polish judges, who now became the target of the attack of the ruling party. And many of those judges, the fact that they are so courageous, I believe it encourages those in other countries where there are breaches of law, and the fact that you all are involved, this gives force. Coming back to Polish judges, many of them are now facing dramatic choices. Either they will apply the law honestly and decently and expect repercussions. You will hear about them, repercussions from the part of the government. Or they will keep silent and be passive in respect to injustice, afraid of injustice, but also I would say it's very difficult to demand heroism from people. Sophie is a very experienced member of the European Parliament, but the fact that she is joined in organizing today's meeting by Michał Šimečka, who is our new member, this is wonderful to have such colleagues who are involved in those issues which are crucial and will be crucial for this term of the European Parliament and European Commission. So really, I'm very impressed. Now, ODF, the Open Dialogue Foundation, you know, as far reaches much further than only European Union. They are active in Eastern Europe, outside of the European Union, and in Central Asia, and everywhere where human rights are being where people are being harassed for their political involvements and human rights are being broken. And we have here Mr. Kamek with us, and Ludmila Kozłowska. Her story also is worth a book, honestly, and it's not finished, and I wish you a lot of courage. Thank you very much for organizing this, but you know what is characteristic, what's going on in my beloved homeland. With the Open Dialogue Foundation, people from today's government, I will call names, Mrs. Kempa, Mr. Jaki, Saryusz Wolski, Czarnecki, etc., cooperated, as far as I know, very well with the Open Dialogue Foundation, up to the moment when the foundation started criticizing breaches of law in Poland. And then they underwent an incredible attack from the side of the public media, which are not public really anymore, and from the side of the government. But you don't give up, and please do not give up. Continue your involvement, not only for Poland, it's the whole Europe and further than that. Now, I am extremely honored that we can sit in one row with those people you see on my left, who stand for justice in Poland, who realize that so much depends on them today, who didn't break down under this incredible pressure that is on them. They realize that after they will come back to Poland, after this meeting, there will be a shitstorm of hate and accusations against them, that they are traitors of the country because they came to talk to the European Parliament, to all of you. They will be accused of betrayal of the country. They will be called traitors and targowica, which they are anyhow until now, but the trolls and haters are already warming up to start. And they realize it very well, and still they are here, because we feel all co-responsible for the level of justice and human rights in the European Union. And the last sentence I would like to add is the worst advisor is fear. The worst advisor is fear. And it's terrible when you come to a situation that being decent, being honest, following the rule of law, demands from you not only decency, but demands from you courage, endurance, special devotion to the cause. And I think I would like to tell you, in the name of millions of Poles and other citizens of the European Union, a great thank you. Thank you very much.
Thank you very much for giving me the floor. I'm the spokesperson of the Association of Judges, of Polish Judges Themis. It's a great honor to have ability to tell you what is going on in Poland, especially that we are at the kind of turning point for the independence of Polish judiciary, because in April this year the term of office of current first president of Supreme Court, Ms. Małgorzata Gersdorf, expires, and at that moment probably there will be the new president appointed without serious help in from European Union, namely application of interim measures. I'm afraid that it will be completely politically dependent new president, and such kind of action, the defeat of the last standing central judicial authority which is independent, can break the spin bones of judges of ordinary courts. Very shortly about the changes in Polish judiciary, in Polish legal system. They all started from taking control over constitutional tribunal. It was unconstitutional and taken over, and this means that very small law and justice majorities of seats in parliament is able to adopt any law, even unconstitutional. Afterwards, the ruling camp took political control over the public prosecutor office, which was achieved by combining functions of Minister of Justice and Public Prosecutor General, which has been accompanied by significant increase of his investigative powers. And Minister of Justice has been enabled to appoint the superior prosecutors instead of competition procedure applied before, and it was accompanied by exchange of top prosecutors under the pretext of reorganization, and the result of these changes is the image of public prosecutor office as potentially entirely disposed to the ruling party. What is more, at the very top of the public prosecution office, the Internal Affairs Department of the State Prosecution Service was created, which statutory aim is to conduct and supervise preparatory proceedings in cases of crimes committed by judges and prosecutors. During more than 2 years of its operation, they commenced 2 proceedings against specific judges. If we take under consideration that there is 10,000 judges in Poland, this number is insignificant, and it clearly shows that this special unit was created just to incite the chilling effect among the judges. Afterwards, we were facing the amendment of the Act on the Organization of Ordinary Courts, which enabled the Minister of Justice to arbitrarily dismiss presidents and vice presidents of courts, and Minister of Justice do it in respect of about 160 persons before their terms of office expired, and the new presidents were appointed who are absolutely loyal to the ruling camp, and many of them now exercise their power by applying soft administrative measures of repression in respect of defiant judges. Afterwards, the complete part was done within the National Council of the Judiciary, which had previously played a fundamental role in safeguarding of the independence of the judiciary, because the main constitutional right of this body, the obligation, is protection of judicial independence. So this body evaluates candidates for judges, candidates for higher judicial positions, and has the right to set out the rules of professional ethics for judges. Contrary to our constitution, the prerogative of appointing 15 judges members was transferred from judicial self-governing bodies to the Polish parliament, and simultaneously they terminated the terms of office of the members of the old council. In fact, the new members of National Council of the Judiciary, according to the new law, were obliged to gather 25 signatures of support from other judges, but this list of support have never been revealed to the public. So we don't know if, even according to this new regulation, these members of NEO-NCJ were correctly elected. These lists were never revealed in spite of the valid sentence of the Supreme Administrative Court. And this National Council of the Judiciary was turned from the effective guardian of judicial independence into body suppressing independence of the judiciary. For example, when they assessed judges for the promotion, previously it was like that the judges who were best evaluated by the local assemblies of courts, by the judges' visitors, were promoted. Now, those judges who are the worst are promoted by NEO-NCJ because they guarantee absolute loyalty to the ruling camp. And there was motives of one of the decision of NEO-NCJ why they promoted the worst judge. It was written exactly like that. The fact that this judge has very high rate of verdicts squashed by the second instance proves his independent way of thinking. I would add this independent way of thinking from logic and from professionalism. And there is, of course, huge number of personal direct connections between members of NEO-NCJ and Ministry of Justice. Most of members of this new body were promoted by the Minister of Justice, and they became the presidents of the courts. Now let's move to the new act on the Supreme Court. Originally, it was drawn up to enable a part of the personnel in this highest judicial body by the reduction of the retirement age for judges. Of course, it was stopped in October 2018 by the interim measure applied by the Court of Justice of European Union, but in spite of that, there were created two entirely new chambers within the Supreme Court, which are strictly politically subordinated. From the point of view of judges, the most important body is the disciplinary chamber, which is the second instance court in disciplinary proceedings in respect of judges. And I must add that this disciplinary chamber has its own president, completely independent from the first president of Supreme Court, own budget, own office, own spokesperson, and own rules of the procedure. So in fact, it is completely new court, just acting under the auspices of the Supreme Court. This court is not provided by the Constitution. Creation of such specialized court is possible only in times of war. So it is not a court provided by law in the meaning of Article 6 of European Convention of Human Rights. And the mode of election of the new judges to this disciplinary chamber and the second new chamber was in fact quite fun. It remained rather the beauty contest than the real competition for the high professional position, because the Neo-National Council of the Judiciary skipped requirements concerning examination of the files of the candidates, so the only one criterion of assessment was the talk between the candidate and 3 members of Neo and CJ, which lasted between 8 and 15 minutes. So in fact, it is much easier now to become a judge of ordinary court than a judge of the Supreme Court. So it shows that not professional reasons stood behind the decision on nomination to this disciplinary chamber. Alongside with the disciplinary chamber, there was simultaneously introduced the new mode of disciplinary proceedings in respect of judges, which massively undermines the right to the defense, because it is permissible to carry out a hearing in disciplinary proceeding in justified absence of the judge and his counsel, and it is possible to apply evidence obtained without judicial control and in violation of law, including the evidence from operational telephone typing. And what is even more, the Minister of Justice appoints the main disciplinary commissioner for judges and his 2 deputies, and all judges in the first instance disciplinary courts. So the Minister of Justice has overwhelming personal influence on the new mode of disciplinary proceedings. So in fact, it is an inquisitional model of disciplinary proceedings against judges, which politicized the proceedings and massively restricted the procedural right of the defendants. We can differentiate 2 ways of frightening judges, of intimidating judges, of putting pressure. First, we can call them hard measures, which are possibility of commencing disciplinary proceedings, and the second branch of these hard measures is commencing criminal proceedings. As you can see from this slide, at the pre-trial proceedings in respect of defiant judges is always commenced by central disciplinary commissioners appointed by the Minister of Justice. At the trial stage, the judges of first instance were all appointed by the Minister of Justice arbitrarily, and in the second instance, we face the disciplinary chamber of the Supreme Court, which members were appointed by Neo-National Council of the Judiciary with indirect influence of the Minister of Justice. And if the power camp wants to instigate criminal proceedings in respect of judge, it has at the disposal the Internal Affairs Department of the State Prosecution Service at the top of the prosecution. So we are surrounded from every direction. We have also these soft measures of repression, which are applied mainly by the president of courts, newly appointed, and the Minister of Justice. And there is quite wide range of measures like transfer judges between divisions, deteriorating of working conditions, liquidation of division of court in order to deprive particular judge of functions, and many other measures. What are the typical categories of sensitive cases in which these soft or hard measures can be applied? It is applied in respect of judges who refer preliminary requests to the Court of Justice of European Union, judges who decide directly on the basis of constitution or international law, judges protesting against the breach of constitution, politicization of the judiciary, judges involved in legal education of children. Quite recently, we were facing the very serious black PR campaign against judges, which was called Billboard campaign. We have 1,000 great billboards around all Poland describing some real, some alleged, some manipulated situations of misbehavior of judges. One real situation was that the judge has stolen trousers from the shop. This situation has happened, but they didn't mention that the judge was for many years retired and that he was mentally ill. And there were such a huge billboard, and one of the judges very accurately commented that the situation in which one of branches of state authority pays to organize negative campaign against another branch of state authority of the same country is so peculiar that even George Orwell or Monty Python couldn't have come up with that. And that is absolutely true. Afterwards, we have a wave of speeches of our Prime Minister saying that Polish judiciary is a part of post-communist pact, which is a paradox, as the average judge is 42 and the change of the system was 30 years ago. The information that Polish judges are corrupted, which is absolutely not confirmed by the statistics and by the Greco reports. And at one of the meetings with President Macron, the Polish Prime Minister compared Polish judges and Polish courts to the courts of Vichy France, collaborating with the Nazis. And quite recently we faced so-called troll farm in the Ministry of Justice. So there was a group of 12 judges rooted in the Ministry of Justice who organized a smear campaign against the defiant judges. One of their famous actions was inciting in the internet the public to send postcards to the first president of Polish Supreme Court, get the fuck off from the Supreme Court. In this group there were involved 3 members of Neo-National Council of the Judiciary, 2 deputies of the main disciplinary commissioners, and one of the members, new judges of the disciplinary chamber. So this example clearly shows that all newly created bodies are morally compromised and politically corrupted. What else?
Can I ask you to
go
towards a conclusion?
Okay. Conclusion. What is the conclusion? 2 politicized committees were created in order to subordinate Polish judiciary. One is Neo-National Council of the Judiciary, which is responsible for appointment and promotion of judges. So, in general, that they pump new judges to the top positions who are absolutely loyal to the ruling camp. And the second such committee, politicized committee, is disciplinary chamber of the Supreme Court, which is responsible for legal harassment of defiant judges. So we have very nice equilibrium. One body is pulling new loyal judges, another one is going to throw out these who are not loyal to the politicians. There is full control of the Minister of Justice over the prosecutor's office, over the disciplinary proceedings, an excessive level of administrative control over the judiciary, and such very strong position of Minister of Justice has great potential of intimidating of judges, and it is a real chilling effect generator. The idea of political subordination of the judiciary is supported by the massive Black PR campaign, including media, internet, billboards. All these forms of slandering of the judiciary and particular judges are either organized and financed or at least supported by the executive. This internet part of negative campaign against judges is clearly, completely Putin-like project, and all these tools of oppression, which I tried to describe within 10 minutes, are engaged to suppress judicial independence and to disable application of the European Union law by the Polish courts.
You only caught your breath once, I think. Thank you very much. I have the rather ungrateful task today of making sure people stick to their speaking time. And I realize that there's a lot to say, but I think there are also a lot of questions. We have a few more panelists. So I'm going to ask the next panelist to really stick to the allocated speaking time, because afterwards in question and answers you will still have the opportunity to make further remarks. So the next speaker of mine is for 7 minutes strictly is Judge WALDEMAR ZUREK. Mr. ZUREK, you have the floor.
Halo, jest. Witam Państwa bardzo serdecznie. Mam bardzo mało czasu, będę mówił po polsku. Postaram się mówić powoli. Miałem mówić o szykanach wobec mojej osoby. One są naprawdę bez precedensu. Ale zacznę od czegoś innego. Gdy przyjechaliśmy tutaj do Państwa, dowiedzieliśmy się, że właśnie tak zwani rzecznicy dyscyplinarni powołani przez ministra prokuratora generalnego wszczęli postępowanie dyscyplinarne 3 sędziom, którzy w orzeczeniu sądowym zapytali polskiego Sądu Najwyższego, jak należy wcielać w życie wyrok Trybunału Sprawiedliwości Unii Europejskiej. To są rzeczy bez precedensu. Za orzeczenie, za pytanie prawne do Sądu Najwyższego kraju związkowego stawia się zarzuty dyscyplinarne z dnia na dzień. Kilka tygodni temu sędzia Paweł Juszczyszyn z Olsztyna, który domagał się ujawnienia list poparcia do tej nielegalnej Krajowej Rady Sądownictwa, został odsunięty od orzekania. To pierwszy taki przypadek, myślę, że w Unii Europejskiej. Sędzia, który stosuje procedurę przez prezesa powołanego znowu przez ministra sprawiedliwości, prokuratora generalnego, jest odsunięty od orzekania. Mój pełnomocnik, szef największego stowarzyszenia sędziów, profesor prawa Krystian Markiewicz, za list skierowany do sędziów, gdzie prosił o przestrzeganie prawa i miał te same zarzuty co Komisja Europejska oraz Rzecznik Generalny Trybunału Sprawiedliwości w Luksemburgu, zostało mu postawione 55 zarzutów dyscyplinarnych. Proszę Państwa, to są rzeczy, które nam nie mieszczą się w głowie, sędziom wychowanym w wolnym kraju. Przejdę teraz krótko do szykan wobec mojej osoby. Powiem je bardzo skrótowo, dlatego że mógłbym opowiadać ze szczegółami kilka godzin. Najpierw oczywiście zaproponowano mi uzyskanie jakichś stanowisk z nominacji nowego rządu. Wtedy, gdy odmówiłem, rozpoczęła się kontrola. Najpierw Centralne Biuro Antykorupcyjne kontrolowało moje oświadczenie majątkowe przez 16 miesięcy. Nic nie znaleziono, więc zaczęto kontrolować moją małżonkę, która była wtedy w zaawansowanej ciąży. Skontrolowano mnie w 384 instytucjach finansowych w bankach. Uruchomiono kontrole skarbowe, 3, 2 skończyły się już prawomocnie. Uruchomiono wobec mnie postępowania dyscyplinarne, ale za co? Nie za moje orzecznictwo, najczęściej za moje wypowiedzi publiczne, za spotkania z obywatelami i na przykład za krytykę pseudoreform wymiaru sprawiedliwości. Obecnie mam tych postępowań 5. Byłem 5-krotnie przesłuchiwany przez Centralne Biuro Antykorupcyjne przez wiele godzin. Kiedy już kończyła się kontrola, jeden z moich pełnomocników mówi, no już nic Państwo nie znaleźliście. Wtedy agent powiedział, no w przyszłym roku też Pan złoży oświadczenie majątkowe, możemy zacząć to wszystko od nowa. Takie jest podejście funkcjonariuszy służb państwa. Byłem przesłuchiwany 3-krotnie przez prokuraturę. Jedno z przesłuchań dotyczyło treści uchwał przyjmowanych przez sędziów na oficjalnym zgromadzeniu Sądu Okręgowego w Krakowie. Przesłuchuje się nas na treść uchwał, które sędziowie uchwalają. Dopuszcza się także wobec mnie mobbingu w takiej czystej postaci. Pozbawiono mnie funkcji rzecznika prasowego bez opinii organów samorządowych sądów, z naruszeniem prawa, które obowiązuje teraz. Po wielu latach pracy przerzucono mnie do innego wydziału Sądu Okręgowego. Nie zapewniono mi asystenta, sekretarza sądowego. Zasypano mnie aktami, które przez rok czekały bez przydziału, gdzie w każdej z tych akt była już przewlekłość postępowania. Proszę sobie wyobrazić, że sprawę o mobbing przygotowywał adwokat, który patrzy podobnie jak ja na te zmiany, ale po miesiącu pracy nad tym pozwem powiedział, że on niestety nie może go podpisać, bo obawia się szykan wobec swojej kancelarii prawnej. We wszystkich tych sprawach reprezentuje mnie łącznie 14 profesjonalnych pełnomocników. Wygrywam wszystkie postępowania. Gdy przystępowano do kontroli, nie postawiono mi żadnych zarzutów. Żadnych. Więc sytuacja jest kuriozalna. Przeprowadzono także kontrolę mojego referatu, czyli mojej pracy orzeczniczej jako sędziego. Osoba, która przeprowadzała tą kontrolę, sędzia wizytator sądu wyższej instancji po miesiącu przestał być wizytatorem. Więc te szykany dotyczą także osób, które, no oczywiście są też bardzo niemiłe rzeczy, takie jak ogromny hejt, agresja na ulicy, pisanie maili, SMS-ów, telefony, także czasem nocą, które grożą. Mój dom rodzinny, gdzie mieszkają moi starzy rodzice, został obrzucony jajkami, więc to jest taka presja także na osoby z najbliższej rodziny. Nie chcę mówić o wypowiedziach na przykład jednej z parlamentarzystek, która została ostatnio sędzią nowego Trybunału Konstytucyjnego, który jest dzisiaj pewną wydmuszką, a nie organem. Napisała na Twitterze z imienia i nazwiska wymieniając jej, że mam krew na rękach, jestem zdrajcą. Ja jestem człowiekiem, który jako młody, bardzo młody człowiek walczył z komunizmem. Rozlepiałem ulotki, byłem w takiej organizacji wtedy nielegalnej. Moi rodzice należeli do Solidarności. Dzisiaj nazywa się mnie komunistycznym sędzią. To, co się dzieje w Polsce, proszę Państwa, ja jestem jednym z wielu, ale to szykany są już wobec kilkudziesięciu sędziów. Bardzo poważne. My musimy jeździć na postępowania dyscyplinarne po całej Polsce. To bardzo utrudnia nam pracę merytoryczną i być może jest to celowe działanie, żeby po prostu złapać nas na tym, że popełnimy jakiś błąd w pracy zawodowej. Mój czas się skończył. Piszemy raporty dotyczące szykanowania sędziów. Taki raport sporządzała Komisja Senacka, niezależna jeszcze od rządzących, więc myślę, że Państwo powinniście się zapoznać. On jest bardzo szczegółowy. My mamy poparcie dokumentacji. Także Stowarzyszenie Sędziów Iustitia pisze raport o sędziach szykanowanych z imienia, nazwiska, rodzajach szykan. Bardzo Państwu dziękuję za uwagę.
Okay, I would like to speak to you in Polish because my English is no good to express everything so clearly. Stowarzyszenie prokuratorów Lex Super Omnia powstało jako odpowiedź na politykę kadrową prokuratora generalnego, ministra sprawiedliwości Zbigniewa Ziobry, polegającą na tym, iż zdegradował on do jednostek niższego szczebla blisko 1/3 prokuratorów z 2 najwyższych szczebli prokuratury. Prokuratorzy ci zostali przeniesieni bez prawa do jakiegokolwiek odwołania, bez możliwości zaskarżenia podjętej decyzji na inne stanowiska służbowe do prokuratur niższego rzędu i była to swego rodzaju kara dyscyplinarna nieprzewidziana żadnymi przepisami. Przerwane w ten sposób zostały kadencje prokuratorów kierujących poszczególnymi jednostkami organizacyjnymi. Stowarzyszenie Lex Super Omnia, mimo przysługującej prokuratorom wolności do zrzeszania się, zostało zarejestrowane dopiero po 8-miesięcznej batalii sądowej. Lista członków założycieli tego stowarzyszenia została skopiowana przez prokuratora okręgowego w Warszawie, który podjął wobec członków stowarzyszenia działania o charakterze represyjnym. Osoby, które widniały na listach członków, zostały objęte szykanami, zostały pozbawione funkcji kierowniczych. Osobiście jestem tego przykładem, praktycznie z dnia na dzień zostałam przesunięta, zdegradowana ze stanowiska i przesunięta w delegację do innej jednostki bez zgody, bez jakiegokolwiek wytłumaczenia na okres łącznie 1 roku i 3 miesięcy. Od momentu powstania stowarzyszenie Lex Super Omnia i podejmowane przez niego działania w obronie wymiaru sprawiedliwości i zasad praworządności spotykają się z represjami o charakterze służbowym. Wszczynane są wobec nas postępowania dyscyplinarne za wypowiedzi w obronie niezależnej prokuratury i niezawisłych sądów, za udział w zgromadzeniach publicznych, wystąpienia w mediach. Prokurator generalny, czynny polityk Zbigniew Ziobro wnioskuje o uchylanie prokuratorom immunitetów w celu prowadzenia przeciwko nim postępowań karnych z powodu wydawanych przez nich decyzji procesowych. Proszę Państwa, moja 18-letnia córka co jakiś czas mnie pyta: mamo, co z Tobą będzie? Czy Ty masz w ogóle jakiś plan B? Wszystkie te działania, zorganizowane działania mają na celu ukaranie prokuratorów za ich czynną aktywność na rzecz praworządności. Z drugiej zaś strony ewidentnie mają na celu wywarcie efektu mrożącego na pozostałych prokuratorów, tak aby posłusznie i bez głębszej refleksji realizowali wytyczne prokuratora generalnego. Degradacja prokuratorów w roku 2016 była pierwszą, największą i zorganizowaną ustawowo operacją szykanowania prokuratorów. Zniweczyło to ich dotychczasowy dorobek zawodowy, pozbawiło tytułów służbowych. Wobec prokuratorów aktywnie występujących w obronie niezależności prokuratury, w obronie praworządności prowadzone są postępowania wyjaśniające, dyscyplinarne, postępowania służbowe za wykonywanie obowiązków, w związku z wykonywaniem obowiązków służbowych, przy czym bardzo często przynależność do stowarzyszenia jest dodatkowym elementem obciążającym. Szeregu prokuratorom, członkom stowarzyszenia zostały przedstawione zarzuty dyscyplinarne, uchybienia i złamania zasady apolityczności poprzez wypowiedzi w mediach bez zgody przełożonych, chociaż żadne regulacje ustawowe takiego obowiązku na nas nie nakładają, za udział w posiedzeniach komisji sejmowych, wysłuchaniach publicznych w Sejmie, za wystąpienia w obronie Sądu Najwyższego, wolnych sądów i za krytyczne wypowiedzi względem zmian legislacyjnych w tym zakresie, czy wreszcie również za publikację artykułów o tematyce prawnej. Prezes naszego stowarzyszenia, który za chwilę zabierze głos, jest tego dobitnym przykładem. Wobec prokuratorów są podejmowane różnego rodzaju szykany. Nieproporcjonalnie obciążani są bieżącym wykonywaniem obowiązków służbowych, często zmienia im się te obowiązki, przenosi do innych jednostek, utrudnia wykonywanie obowiązków poprzez wskazywanie jako miejsca pracy często pomieszczeń, które naprawdę urągają powadze urzędu. Pozbawiani są, tak jak tutaj już panowie sędziowie mówili, pomocy asystentów. Kumulacja tych wszystkich negatywnych zachowań, choć wydawałoby się one pojedynczo na pozór błahe, jest wyjątkowo dokuczliwa i ma na celu zniechęcenie do podejmowania jakichkolwiek zachowań, które są sprzeczne z oczekiwaniami przełożonych, a w szczególności wywołanie efektu mrożącego wśród innych prokuratorów. Aktualnie prokuratura w intencji prokuratora generalnego, ministra sprawiedliwości, a więc czynnego polityka, została sprowadzona do roli narzędzia politycznego w jego rękach, a wszelkie przejawy niezależności prokuratorskiej, która jest gwarantowana ustawą, spotykają się z jego natychmiastową reakcją o charakterze represji. Dziękuję Państwu.
Szanowni Państwo, nazywam się Krzysztof Parchimowicz, mam 61 lat, od 32 lat jestem prokuratorem, a od 3 lat prezesem Stowarzyszenia Lex Super Omnia. Dzisiaj Państwu przedstawię historię nienawiści instytucji do prokuratorów, historię nienawiści do niezależności prokuratora, do prawa prokuratora do zrzeszania się, do prawa prokuratora do wolności słowa. Będę tą historię nienawiści przedstawiał na swoim przykładzie, niemniej, aby uniknąć egoizmu, powiem, że Ewa, która mówiła przed chwilą, ma niewiele mniej ode mnie postępowań dyscyplinarnych, bo 4. Natomiast ja należę do tej grupy prokuratorów, która została zdegradowana wiosną 2016 roku. Na podstawie jednego zdania dowiedziałem się, że przestaję być prokuratorem prokuratury generalnej, czyli najwyższego szczebla, i od jutra staję się prokuratorem prokuratury rejonowej, czyli prokuratury najniższego szczebla. Na tym najniższym szczeblu już pracowałem w młodości. Natomiast w prokuraturze generalnej przez 20 lat występowałem reprezentując prokuratora generalnego przed Sądem Najwyższym. Z jednego zdania pisma dowiedziałem się, że moje doświadczenie, moja wiedza nie liczą się i zasługuje na reedukację, jak to było w trakcie rewolucji kulturalnej w Chinach. Kiedy tworzyliśmy nasze stowarzyszenie, w trakcie już rejestracji prokuratura inwigilowała proces rejestracji. Skopiowano wszystkie dokumenty, skopiowano listę członków założycieli, by wiedzieć, kto z prokuratorów podnosi głowę do góry i nie ulega presji. Później Zastępca prokuratora generalnego do spraw wojskowych nakazał podwładnym, by na piśmie zgłaszali mu zamiar brania udziału w pracach stowarzyszenia. Dalsze szykany związane są już z okresem, kiedy zacząłem być prezesem stowarzyszenia. Wobec mnie prowadzono 2 postępowania karne. Pierwsze po 6 miesiącach zostało zakończone, zaniechane i dotyczyło domniemanego fałszywego oświadczenia o stanie mojego majątku. Po prostu prokuratorzy najwyższego szczebla uznali, że nie jest możliwe w rodzinie, by rodzeństwo zrzekło się spadku po rodzicach na rzecz najstarszego brata. Pół roku im zajęło to, żeby przyjąć do wiadomości, że są takie rodziny, które nie kłócą się o pieniądze. Drugie postępowanie jest w toku. Dotyczy interpretacji przepisów prawa, interpretacji Sądu Najwyższego dotyczącej spornej kwestii, którą przesłałem podległym wtedy prokuratorom. Z tego powodu prowadzone jest postępowanie karne o czyn zagrożony karą do 10 lat więzienia i surowymi karami finansowymi. Prokurator generalny i jego zastępca na konferencji prasowej wskazali mnie z imienia i nazwiska i z funkcji w stowarzyszeniu jako sprawcę tego czynu i zyskałem miano, czy określano mnie przyjacielem mafii podatkowej. Takich normalnych postępowań dyscyplinarnych za działalność publiczną, za publiczne wypowiedzi, za krytykę przełożonych bądź obronę reguł praworządności miałem 5. Jedno jest prawomocnie umorzone, 2 zostały umorzone niedawno w pierwszej instancji, a 2 inne czekają na rozpoznanie przez sąd dyscyplinarny. Ciekawostką jest, że w tych 2 postępowaniach, to taka przypowieść o kondycji duszy ludzkiej, ciekawostką jest, że w tych 2 postępowaniach oskarża mnie kolega, z którym znamy się od ponad 30 lat i nie uznał za stosowne, by się wyłączyć. Chce na siłę udowadniać, że on jest obiektywny i dlatego oddala wszystkie moje wnioski. 14 postępowań to postępowania we wczesnym stadium postępowania dyscyplinarnego, czyli oprócz tych zarzutów wielu mam 14 postępowań w fazie wstępnej. Od marca 2016 roku pracuję już w 3. prokuraturze na terenie Warszawy. Faktycznie od 1,5 roku nie mam stałego miejsca służbowego. Bez swojej zgody jestem przenoszony z prokuratury do prokuratury. Jak jestem dłużej w jakiejś prokuraturze, to zmieniane są mi zajęcia, także ciągle muszę zapoznawać się z nowymi sprawami i pozbawiony jestem możliwości oswojenia się w nowym otoczeniu i nabycia pozytywnej rutyny. A jak Państwo widzą, jestem w wieku, w którym ma zastosowanie powiedzenie, że starych drzew się nie przesadza zbyt często. Trudno w takiej sytuacji funkcjonować, ale wsparcie rodziny, duch koleżeństwa, współpraca środowisk prawniczych pozwala takie sytuacje przetrwać. Ale bywają i gorsze chwile, kiedy moja twarda prokuratorska skóra, twarde serce w sytuacji, kiedy mam zmierzać do miejsca pracy, gdzie panuje atmosfera mobbingu, nie wytrzymują. Wtedy czuję torsję, kiedy idę do takiej pracy. Niemniej to mija. I tak jak obiecałem w Polsce, nie będę się odwoływał w razie niekorzystnych orzeczeń do ludzi, którzy zasiadają w Izbie Dyscyplinarnej i zgodnie z orzeczeniami nie są sądem. Proszę Państwa, kończąc, powiem tylko tyle, że te kilka słów, które Państwu przekazywałem, to jest zapowiedź petycji Stowarzyszenia Lex Super Omnia do Komisji Petycji, by przedstawić, jak bardzo upolityczniona jest prokuratura w Polsce, jak bardzo jest narzędziem w rękach partii rządzącej, jak bardzo polski prokurator pozbawiany jest prawa do stowarzyszania się, do krytyki i do wolności słowa. Chcemy w tej petycji, a właściwie w debacie nad tą petycją, bo mamy nadzieję, że taka będzie, uzyskać odpowiedź na pytanie, czy polski prokurator jest człowiekiem, czy przysługują mu prawa ludzkie i obywatelskie, czy też jest niewolnikiem władzy niegodnym takich praw. Dziękuję bardzo.
Thank you very much. I'm going to open the floor for questions and debate.
Well, first, thank you for you two, for Renew and Open Dialogue for organizing this, and thanks a lot for the speakers for your very impressive exchange of your experience. I mean, it's very depressing and impressing, and it also make us aware that we need to do something. I mean, you're so courageous, and needs to be repeated, I think, and it's important that this legal harassment is not effective. So I would like to know from you, can you keep up the courage? I mean, does it have an intimidating effect, or do you manage as judges to resist, and perhaps, for instance, with follow-up proceedings towards the Court of Justice or other actions? I know that you're very much supported by European judges from other countries, but what would you need more in order to keep the strength? Maybe that we speak out, of course, also, but what do you think that the Polish government would be most sensitive to? Do you think the financial sanctions, for instance, also injunction measures by the Commission? What are your views on what we can do?
Thank you very much. First of all, thank you so much for your testimonies and your presence here. My name is Małgorzata Szuleka. I'm a lawyer with the Polish Helsinki Foundation for Human Rights. I have two questions. One is addressed to judges. In the moment when we speak, just right now, Polish media started to report on still confidential government-sponsored draft legislation changing the provision on the disciplinary regime against judges. In the light of this draft proposal, judges who questioned, among others, the status of judges appointed by the new National Council of Judiciary, or in general questioned the constitutional order of the Republic of Poland, everything could fall under this category, like, for example, asking the preliminary request to the European Court of Justice, will face the threat of dismissing from the office or the financial penalties. I would like to ask about your comments on that, especially given the fact that we have two binding decisions of the top of the courts of the top ranks, the Supreme Court and the ECJ. And the second question would be to the MPs. Yeah, sure. This is my second question. Is that we have an infringement proceeding pending concerning the disciplinary regime. I would like to ask what are the Parliament's plan and political groups in the Parliament towards this particular initiative, and whether there are planned any calls on the European Commission to move forward with these proceedings. Thank you.
I wanted to ask if people in Poland do understand what is the case, and if they do not understand what is the case, then how to explain them what is the case. Because in Czech Republic we had an attempt that was somewhat similar. It was in its beginnings when the Ministry of Justice wanted to shorten the length in which the chief prosecutor can be in the service, and by this basically remove him, because a few days ago we had very important briefing where basically the state prosecutor again opened an investigation of the prime minister. So we had something similar, but there was a huge backlash of people because they understood what is the case. Thank you.
In respect of the first question, what can be done? I've already mentioned that the term of office of current First President of the Supreme Court, who is independent person, expires at the end of April next year. So there will be new presidential election in the Supreme Court. But the General Assembly of Supreme Court is obliged to submit 5 candidates to the President, Duda, who is ex-Law and Justice member and he's backing this party always. So there is enough new judges in the entire Supreme Court nominated by the neo-national council of the Judiciary that they can pass one of the candidates of their own, and it will be totally politically loyal candidate. So it is very dangerous for preserving on the independence of the entire judiciary, as it is the last standing fortress of the independence of the Polish judiciary at the central level. So, in my opinion, it is absolutely necessary to apply interim measures in the cases pending in front of Court of Justice of European Union. First, to freeze this new mode of disciplinary proceedings, including disciplinary chamber, and the second, to exclude the newly nominated judges of the Supreme Court, nominated by the neo-national council of the Judiciary, from possibility to participate in this General Assembly, which is going to elect the new president. In terms of the question of Ms. Szuleka concerning this new law concerning possibility of disciplinary punishing of judges for the acts which are not in favor of the ruling power, I've just made a translation of these new provisions, and I still can't believe that it is possible to pass such a law, because it clearly states that the actions questioning the existence of judge's service relationship or the effectiveness of her appointment, it clearly states that it constitutes the disciplinary offense in the situation in which the Court of Justice of European Union questioned the mandate of the newly nominated judges. So, following 19 November judgment of Court of Justice of European Union is going to be directly punished by the amended law on the organization of ordinary courts. Can you imagine something like that? And according to previous media relations, the first version was not in respect of disciplinary actions for such decisions of court, but just for they were going to introduce the new kind of offense. So it would be completely Turkish-like solution. So this is softer, but the penalty can be removal from the judicial office. So very serious penalty. It's clearly contradictory to implementation of the European Union law, which is going to become a statute in Poland. It's unbelievable.
Jeśli mogę, konkludując, bardzo ważne jest dla nas, żeby w tych sprawach, które toczą się już przed Trybunałem Sprawiedliwości Unii Europejskiej, czy to sprawach Komisji, czy także jeszcze zawisłych w Trybunale spraw zadanych przez niezależny polski Sąd Najwyższy, doszło do zabezpieczenia, które polegałoby na tym, o czym mówił sędzia Mazur, czyli ci nowi sędziowie powołani wadliwie przez bardzo upolityczniony organ, żeby nie brali udziału w procedurze. To jest niezwykle istotne. Jeśli chodzi o tych sędziów, którzy są szykanowani, myślę, że powinniście Państwo, parlamentarzyści europejscy, znaleźć odpowiednią komisję, która stworzy listę sędziów i prokuratorów poddawanych szykanom, zapozna się z raportami komisji Senatu oraz stowarzyszeń sędziowskich, które opisują te szykany, mamy to wszystko udokumentowane, to nie są tylko nasze gołosłowne twierdzenia. I zapyta polski rząd, dlaczego i stanie w obronie tych ludzi, bo to są unijni sędziowie. W sytuacji, gdy każdy obywatel Unii przyjedzie do Polski, ma mieć zapewnione prawo do bezstronnego sądu. Gdy prowadzi w Polsce firmę, musi mieć sąd, który gwarantuje mu obiektywizm w sporze obywatela Unii, czasem z polskim urzędem, czasem z polską firmą, czasem z firmą z dominującym udziałem kapitału rządu polskiego. Więc to jest dla nas bardzo istotne. Krótko chcę odpowiedzieć panu z Czech, który pytał, koleżanka to rozwinie, jak obywatele polscy się do tego zapatrują. Sędziowie polscy spotykają się z obywatelami. Ja między innymi za spotkanie z obywatelami w Lublinie mam jedno z postępowań wyjaśniających, które może za chwilę zmienić się w dyscyplinarne. Sędziowie biorą udział w takich lekcjach w szkołach dla młodzieży, jeżdżą nawet na festiwale młodzieżowe, gdzie opowiadają o zasadach konstytucji i prawa unijnego. Za to mają także wszczynane postępowania. Ale dochodzi do tego także, że dyrektorzy szkół boją się zapraszać z obawy przed tym, że będą szykanowani przez władzę. To jest sytuacja naprawdę bez precedensu w naszej historii po upadku komunizmu. Nie chcę przedłużać.
Pozytywnym efektem tego całego kryzysu praworządności, który ma miejsce aktualnie w Polsce, jest właśnie zbliżenie się prawników, sędziów, prokuratorów, adwokatów do społeczeństwa. Znaczna część społeczeństwa rozumie zagrożenia związane z łamaniem praworządności, popiera nas i wspiera nas w naszych działaniach, stąd dość liczne stosunkowo manifestacje, wiece pod Sądem Najwyższym w obronie wolnych sędziów. Spektakularną dość akcją była sytuacja z próbą odwołania prezes Gersdorf poprzez tutaj zmiany ustawowe. I to jest bardzo jakby pozytywny efekt tej całej negatywnej sytuacji. Natomiast niestety tutaj bardzo złą jakby rolę pełnią media publiczne. Media publiczne, które w sposób w zasadzie zorganizowany deprecjonują sędziów, prokuratorów, afera hejterska, o której tutaj wspomniano, która miała miejsce bezpośrednio praktycznie pod okiem ministra sprawiedliwości. No, tajemnicą Poliszynela jest, że nie mogło to się odbywać bez jego przynajmniej cichej akceptacji. Ostatnie badania, które zostały przeprowadzone, badania takie opinii publicznej, kto jest obwiniany za kryzys praworządności, kryzys wymiaru sprawiedliwości w Polsce, pozwalają na podanie takich danych, że 41% badanych wskazało, że odpowiedzialność za to ponosi partia rządząca, ponosi PiS. Tylko 18% wskazało sędziów. Zatem mam takie przekonanie, że ta świadomość jest stosunkowo duża, natomiast no niestety są też pewne zamknięte na to środowiska, do których bardzo trudno przebić się z tą wiedzą, gdyż no...
Jest jeszcze coś, co się nazywa ekonomiczną presją na obywateli. Rząd zastosował szereg socjalnych programów, bardzo bogatych, które są oczywiście spełniają swoją rolę społeczną, bardzo istotną, ale cały czas używa tej presji politycznej, że tylko ten rząd jest w stanie utrzymać te programy socjalne, które powodują, że znaczna część obywateli nawet w wielu prywatnych rozmowach wypowiada się, że argumentem podczas demokratycznych wyborów jest przelew na konto odpowiednich kwot. To niestety jest niezwykle przykre.
Jednak liczby 250 000 demonstrantów, jak było w Pradze, nigdy nie udało się w proteście czy w obronie praworządności w Polsce zorganizować. Natomiast jedno jest pewne, że obywatele, którzy w pewnych momentach licznie na terenie całej Polski stawali w obronie wolnych sądów, byli świadomi tego, że akcja obywateli i prawników jest wspólna. Obywatele dążą do tego, żeby mieć uczciwe, rzetelne sądy, a prawnicy do tego, żeby mieć możliwość godnego wykonywania swojego zawodu. Bez strachu, ale też bez jakichś propozycji bonusów finansowych. Po prostu by prawnicy byli obiektywni i orzekali zgodnie z faktami i prawem. Natomiast odpowiadając na pierwsze pytanie, to powiem tak, że ten spór, który się toczy w Polsce, to nie jest jakiś wyjątkowy spór dotyczący subtelności prawnej. Spór idzie o podstawową kwestię. Chodzi o to, by polski wymiar sprawiedliwości wyglądał tak, jak w czasach, kiedy ja zaczynałem pracę w prokuraturze. A było to tak, że w sprawie karnej oskarżał prokurator członek rządzącej partii przed sądem czy przed sędzią, który też należał do tej samej rządzącej partii. Do tej samej partii często należał również obrońca, tylko podsądny był bezpartyjny. I teraz władzy chodzi również o to, by w procesie i karnym, i cywilnym, i każdym innym brali udział prawnicy posłuszni tej partii, tej władzy. I chodzi też o to, by wolni ludzie zostali utemperowani rękami prawników, a my się na to nie zgodzimy.
Very quickly, thank you very much for organizing this debate. Thank you most of all to these extremely courageous people who have been, are, and I'm sure will keep on defending the rule of law in Poland. I'm Polish, and I have the deepest respect. My question is, however, to the MEPs present here. The situation in Poland is somewhat without precedent, I guess, in the European Union, although you can see example also in other countries, meaning, for example, Hungary. So my question is, how is there a way to prevent this disease, so to speak, from spreading? Because Poland is cracking, the society is cracking, and we are also European, which means that not only Polish society is cracking, but the European society as well. So what do we do not to break it? Thank you.
Okay.
Thank you. I'm Philippe from Human Rights Watch, and first of all, I want to thank the four panelists for their presence here and your very strong and authoritative testimonies, which in fact kind of contrast a bit with the mood in town when it comes to how to follow up on Article 7 in relation to Poland. And I think we hear, stuff like a fresh start, re-engaging, etc. And what you're talking is really about, retaliation, purge of the judiciary, which is continuing at high speed. So my question is addressed to both the panelists and the MEPs. What would be your advice to the new Commission, and in particular to the two commissioners who are leading the work on the rule of law in relation to using Article 7 in the next few months or year in order to really ensure that Poland is held accountable for what it's continuing to do on the judiciary? Thank you.
Okay.
Proszę Państwa, nam trudno doradzać politykom Komisji Europejskiej, bo widzimy kolej rzeczy z artykułem 7. Nie ukrywamy, że wielu prawników w Polsce lokowało pewne nadzieje w tej procedurze, ale wydaje się, że to jest presja, która nie odnosi spodziewanego efektu. Naszym zdaniem o wiele skuteczniejsze są wyroki Trybunału Sprawiedliwości Unii Europejskiej pod jednym warunkiem, że Unia będzie monitorować wcielanie w życie, czyli wykonywanie tych wyroków w krajach członkowskich. To jest dla nas sytuacja niezwykle ważna, dlatego że polski Sąd Najwyższy kilka tygodni temu wydał orzeczenie w oparciu o wyrok TSUE, kierunkowy wyrok, który był bardzo precyzyjny, a polscy politycy odnośnie tego orzeczenia Sądu Najwyższego mówią, że to nie jest wyrok, to jest stanowisko jakichś tam osób, którego nie będziemy respektować. Te same sformułowania, które padały wobec niezależnego Trybunału Konstytucyjnego w Polsce przed jego rozbiciem i politycznym przejęciem. Nie będziemy publikować nawet orzeczeń Trybunału, powiedziała pani premier, która wtedy rządziła i nie zrobiła tego. Więc od państwa zależy, czy prawo unijne, które jest wcielane wyrokiem sądu unijnego, będzie respektowane w Polsce, czy będzie fikcją.
It's difficult to answer where is the lady, to answer your question, but it's an extremely important one. I would say one point. I see a Polish public television here. No, you are the camera from Poland. So if this camera, if this television related honestly on what we have just heard from judges and prosecutors from Poland, that would already help the Polish society to understand what's going on. The same should happen in other countries. Information and education, those issues are difficult. And I do hope that our common work will really, I follow on the words of Mr. ZUREK, will really help the situation, because Poles are very pro-European and estimate very highly European institutions, our common institutions, and really acting together is for the benefit of the judiciary, independence of the judiciary in Poland, in other countries that we named, but also in all others, so that the disease does not spread. Thank you very much.
Thank you
May
very
I, as an MEP, also answer the question? Or?
That's okay. I'm looking at, well, you know what, then I'm first going to give Michal the floor, because I think you have to really leave by 2. Well, so do I, but...
Wait, but then
let's
just continue, of course.
Okay,
Yes.
you take the floor first.
Thank you very much, and I'll try to also answer your question. And first of all, sort of sitting here listening to the testimonies, it struck me as quite amazing, because I mean, my understanding was that judges are supposed, are the people who speak in measured words and solemn pronouncement, and hearing the 4 of our panelists speaking such clear, stark terms, then testifies not just to their courage, but also to the severity of the rule of law crisis. And there are obviously many kind of legal complexities with the different measures and different laws and different actions, but I think out of this complexity there emerges a clear picture and a clear story which was told, which is the attempt to politically subjugate the judiciary, the prosecution, the rule of law, and the harassment of those who defend it. And the European Union cannot simply, or not the European Union, but this cannot be tolerated in an EU member state. So I think for us, as members of Parliament, it is clear that we, even if, say, the member states or in the council, the situation could be leaning more towards sort of, letting it die out, the Article 7 procedure, or start to re-engage. I mean, of course, engagement dialogue is important, but I think there's a strong and clear political will here in this Parliament, including from our political group, but also others, to keep this up. Also pressure on the Commission to follow up on these developments. There is already on Monday discussion in the Libe Committee in Strasbourg on Monday evening as a follow-up on the Council dialogue, which was this week. So that's another attempt to keep this on the agenda. And then I think, as Judge Zurek very clearly stated, we are in a new situation in which the ruling of the European Court of Justice is basically being disregarded. So it's no longer just about national judges arguing against politicians, but there's a European Court of Justice, and European law is being undermined, and those who want to apply it are being harassed. So I think this should also be a wake-up call for the European institutions. That's all from me. I do apologize, I have to run to the airport, but thanks everyone for coming, and it's great such an attendance, and I think it shows the kind of support that there is for the cause of the rule of law in Poland. Thank you very much.
Thank you very much.
Yeah, I think besides speaking out publicly in support of the judges and criticizing the Polish government, we have, of course, an important role in pushing the Commission for using its enforcement role. And that is political control. And I think that we should push, indeed, the Commission for making sure that there's no impunity. The Court of Justice has been clear. So interim measures, injunctions should come immediately now, I think. And we could also push the Commission for more transparent monitoring, so that also the Commission that investigates what's going on and shares that with the different institutions of the EU. I think this is very important, and keep it on the agenda. And I should also say that we need to ally with our members of national parliaments so that they can also push their governments, the national governments, for speak out in the council in order to not let it go, what the Polish government is doing.
Thank you. Okay, my own 2 cents worth. There are a number of things that we can do, but I think we all need to be very honest to ourselves. The main ingredient is political will. You cannot, and I'm saying this because I know there are different political views around the table about how the European Union should be organized. You cannot, on the one hand, say the European Union is purely a cooperation between national governments, and at the same time expect the European Union to intervene when the values are trampled on. The two don't go together. I mean, this is something those who are there. I can see, because in different countries there are rule of law issues. And all depending on which political color happens to be in power, the political groups of this house are, more or less critical. And this goes for all political groups, including my own. But this is really a question we have to ask ourselves. And I think we should also recognize that the intergovernmental Europe, which comes together in the Council, is simply not equipped to deal with this kind of questions. I mean, just imagine there are 28 government leaders sitting around the table. They're all having lunch together, and then, I don't know, or dinner, and the Dutch Prime Minister is sitting next to Viktor Orban saying, Viktor, can you please pass me the salt? By the way, can you leave the judiciary alone? It doesn't work. It really serious. It's not a joke. It doesn't work that way. So if we want the European Union to really, really uphold those values, we also have to equip the European Union with the powers to do so. That's one. Secondly, we have a number of instruments, and we are developing instruments like the mechanism, the so-called DRF Pact, the Democracy, Rule of Law, Fundamental Rights Pact, that this House has called for already 3 years now. Because then at least, if all the member states are monitored, none of them can hide behind the argument anymore. Oh, why us? We're the victim. Oh, but they too, but they also have problems. Everybody will be measured by the same standards, by the same yardsticks. I think that would be helpful. Thirdly, I think we also need to look at funding. I have some question marks over the whole conditionality issue, because it's not the strong instrument that some people believe it is, but I do have a bit of difficulty listening to all this, and at the same time knowing that the Polish government in the Council today is going to ask for massive amounts of money in order to implement the Green Deal. Difficult. If you don't respect the rulings of the European Court of Justice, then you should simply not be part of the European Union. It's that simple. You want to be part of a club, you play by the rules. Full stop. You want to be, if you want to be on a football team, you cannot have your own rules. You have to play by the rules. Otherwise, don't play football. And I see a serious risk of this issue, not just destroying the rule of law in Poland, but like a virus getting into the EU institutions. Because Poland at some point will also have to nominate, a judge for the European Court of Justice, a member for the European Prosecutor's Office, members in Eurojust. Poland is participating in all sorts of information sharing, police and justice cooperation. We're setting up interoperability with a single search function to search all the databases in the whole of Europe. Do we feel comfortable with the Polish authorities getting access to that kind of information? No? And this has to be addressed. Now, there's a new European Commission. And I have to say, on the one hand, Mrs. von der Leyen, before being confirmed, spoke very tough language about the rule of law. But she toned down her voice when it came to actually getting the nomination of the Council. Now, I hope that was only temporary, and that this Commission is going to be much tougher. I mean, much tougher than the previous Commission. Because I think the previous Commission, although in the case of Poland they did very timidly take some steps, they outsourced it mainly to the European Court of Justice. Hungary was mainly left alone, and the Commission has also ignored the systematic nature or the systemic nature of the violations. Because it's not just the judiciary, it's NGOs, it's media, it's women's rights, it's gay rights. rights, it's academic freedom, and all the rest of it. It's part of an authoritarian, anti-democratic agenda. Let's recognize that. And the Commission and the Council have to take their responsibility. We have written a letter today to the Council asking them to urgently discuss the situation in Malta, where we see different but comparable problems. If they don't respond quickly, then the changes become irreversible. Because what are we going to do? Let's say one day there will be a sensible government in Poland. What are we going to do? Sack all the judges that have been appointed by this government? I mean, where's that going to end? So Commission, Council, Member States, take your responsibility and act quickly and with determination. I think that would be my response. So you'll have the backing of the European Parliament for all of this, cross-party. Okay, I would like to thank all the speakers, not just for being here and sharing your thoughts with us, but in particular for standing up for justice, standing up for what you believe in, showing courage and not being intimidated. So keep up the good work. You have our support. Thank you very much. Thanks everybody else for coming. Thanks to the colleagues. And